The writ of habeas corpus is designed to give a person who complains that he or she is being unlawfully detained, and that was M47's complaint, access to the courts to have the lawfulness of the detention determined. Literally, it commands the person who has custody of the individual to, quote, have the person's body, unquote, before the court at a named time and place. The writ is frequently addressed to the governor of a jail, but it may be addressed to the officer in charge of an immigration detention centre, for example, or the superintendent of a mental hospital. Once the individual is before the court, the custodian must confirm that the individual is in custody, state when and where the person was taken into custody, and show good cause why the person should continue to remain in custody. Habeas corpus is the remedy by which representatives of the state are brought to account for their detention of the individual. The Petition of Right of 1628, I'll read a tiny bit from it, and later it became, although expressed as a petition from the Parliament to the King, it was treated as a statute. The part I want to read is Clause 8, or part of Clause 8. It said, "They," meaning the parliamentarians, "do therefore humbly pray your most excellent majesty that no man hereafter be compelled to make or yield any gift, loan, benevolence, tax, or such like charge without common consent by Act of Parliament." So there's the idea again, the rule of law. "And that none be called to make answer or take such oath or give attendance or be confined," in other words imprisoned, "or otherwise molested or disquieted concerning the same or for refusal thereof." There is a clear connection then between the Petition of Right that I've just quoted from and Dicey's first meaning of the rule of law. In 1667, when he fell from power, Clarendon was impeached. And one of the charges against him was that he had sent persons to, quote, remote islands, garrisons and other places, thereby to prevent them from the benefit of the law, unquote. That's exactly what he did. Clarendon fled and later died in exile. It was not until 1679 that the House of Lords, by a majority of only 57 to 55, passed the Habeas Corpus Amendment Act. Section 11 of that Act remedied the position, and since that time, devices to circumvent habeas corpus have been labelled unlawful in the United Kingdom. The reason that Act is of some special interest is the votes, 57 to 55, in the House of Lords. The House of Commons was in favour of it. It's pretty certain that the Lords did not vote 57 to 55 in favour. The story, which seems to be accepted, is that it was lost before the House of Lords, but one very fat Lord was counted as about 10 votes in favour, and through this device, somehow, the recording of the vote of 57 to 55 in favour passed muster and was never questioned. So this Act, which we today think of as a most important hallmark in favour of the rule of law, really probably didn't pass according to law. It was a condition that no monarch could again rely on divine authority to override the law. The Crown's power to suspend the operation of laws was outlawed. There were prohibitions against excessive fines, excessive bail, and the infliction of cruel and unusual punishment. Jury trial was also protected. So there was in the Bill of Rights, although not expressed as rights of the individual, expressed as limitations on executive power, there was quite a raft of protections for the individual against the exercise of arbitrary power by the monarch. We did not have security of tenure of the judiciary entrenched at the time of the Bill of Rights. However, in 1701, when the Act of Settlement was passed on the accession of Queen Anne, it did provide for the judiciary to be immune from civil suit or criminal prosecution for acts done in a judicial capacity. Well, the importance of the independence of the judiciary for the rule of law, I think, is obvious enough. You only need to look at some countries where judges do not have security of tenure to see how rule by law is overcome and circumvented if judges can be easily removed or can be harmed in other ways.